to implement the Act. There must be a nodal authority, because it has to be, it has to have a nodal, if I may say so, a network must be so strong that otherwise it will not have any effect. It's very difficult to control, for the National Commission to control everything sitting in Delhi or wherever it may be. It must have nodal authorities. And so far as the execution of the orders of the tribunal and execution of the orders of the commission is concerned, it is said it will be executed in an order of a civil code. That makes the position very difficult. A civil code execution, it takes years. Civil court orders takes years. I mean, the order will become virtually an order on paper. Therefore, this has to be considered a little more carefully. And a chapter should be specifically made for offences and penalties, as to whether an offence this will be an offence, cognizable offence. Because the offences and penalties, because in our country the laws are never implemented unless there is a very valid threat against its violation. The offences and penalties and execution, I would rather suggest instead of execution, if the appellate authority or the commission, both the appellate authority and the commission, should be given contempt powers, which has been given to the Central Administrative Tribunal. They have been given contempt powers. The Contempt of Court Act should be made available to them. Otherwise, if you make it executable as a court degree, as a civil court degree, you know the fate of civil court degrees. So I would suggest a sort of a little more reconsideration of these provisions. But this is as a draft, as a comprehensive legislation, it's a very welcome step. And I would request the persons who are involved in this, the law professors, law teachers, to discuss this aspect and several other aspects. Because this act has been conceptually very good. But we have to look at the practical aspect, the technical aspect. How do you implement the act? Because its definition section runs into very many sections. But the act is slightly diffuse. It has to be made more compact. And it has to be given a little more teeth. But I really congratulate Professor Tare, Professor Dubey and others, members of the IIT, different of this country, for giving us very serious thought to this burning problem. And I thank them for sharing my thoughts with you this afternoon. Thank you.
Thank you so much, sir. I believe, obviously, sir has pointed out some of the very technical, very strong technical mistake which we should have looked into. The qualification of commission, should not be lower than qualification of appellate tribunal. We will take care of this particular thing. And we had a lot of discussion on this particular issue, that should we create it as a environmental, it's a civil court power or offense, but somehow we are still not very convinced within ourselves. But whatever you were telling, sir, we should take care, because you have also told, and Dr. Rajendra Singh also told of this particular fact. Even Dr. M.C. Mehta also told the same thing. So we're going to look into this particular thing. Before I open the session for the discussion, I had some queries to the panelists, and I will request panelists if they kindly give the answer on this, and then we possibly go for opening the session. One thing is very clear from all the panelists that they are expressing their opinion in affirmative that we require to have a comprehensive legislation. Justice Ganguly has clarified this particular point that constitutionally we do not have any problem to pass this particular legislation because constitutional frame supported into this particular case what Dr. Uday Shankar was mooting. And it is also come out from this discussion that this particular legislation should be comprehensive and it should include the aspect whatever possible to include within this particular legislation for protection of this particular river. Now I have one question which has been debated within ourselves also, but it's not very clear on this particular point. I would like panelists to answer. Can the tributaries, because some people say the tributaries are the state river, they are not the interstate river, but when the tributary is connecting with the mainstream, they are actually carrying their water into the mainstream. So if the water is polluted or the tributary is polluted, main channel also getting polluted. So will it be any difficulty if we have some sort of a comprehensive legislation which even cover the tributaries too, along with the main channel? So may I request Dr. M.C. Mehta to respond on this, then I will come back to Justice Ganguly to respond on this.
No, frankly, you see, as far as this comprehensive legislation only on river or all the rivers, the tributaries in the Ganga basin, you know. So that's a technical thing, and I am afraid it is nothing going to happen. Frankly, we should have a approach. We should be, monitored, time bound, so that Ganga can be cleaned in any case. Already so many years have passed. So, if you ask me, personally, I'm not in favor of the comprehensive legislation. But as far as the Honorable Justice Ganguly has said, he is right that a law can be created, and that is what is the, I think, opinion of all of us. You know, there is no problem the central government can enact. But for a national river, the first step should be for the national river, not for the, the whole of the Ganga basin, because as he has said, the 9 lakh kilometers, how can will you be able to do that? And then the municipal bodies, there are 300 towns in the Ganga basin, and all the 300, this case is before the Supreme Court, and they have said, we don't have money. Now the new colonies are coming up, the new townships are coming up, they don't have any sewage treatment plants or systems, there is nobody is forcing them to do. So if you create this legislation, the first thing is that we should be, whether, as my friend has said, it should not be 2012, it should be 2013. I wish that it should become a fact of life, that yes, it will be. It will never be. Because in 1990, when Maneka Gandhi was the Minister for Environment, she, at that time, it was she said, one day she called me and she said, please, if you can help me in this Environment Court's bill, because I want to take seriously the Supreme Court, this recommendation. And then she called all the law secretaries in the Ministry of Environment itself, and she told them that, okay, how much time you are going to take in drafting that legislation. And all the bureaucrats, they saw at each other, and then they said, we will take 3 years. And then she asked me that how much time, if I said, if you want to do something, you want to help the ministry. I said 3 months. And then I requested Justice Bhagwati, many other legal luminaries, and we drafted in 2 months' time the whole thing, and it was discussed in an open house. But the fate of that legislation is nowhere. So I'm talking about 1990s, and it is 2012. So we should not be too much optimistic that yes, tomorrow the law secretary is going to make a bill, and just draft a bill, and he will introduce into the parliament. I'm doubtful. But yes, efforts should continue. We should be very serious, and the government, if at all they want to do something, the government, if the Prime Minister can say it is a national river, then at least the national river should be seen. So this is the point, and for that comprehensive legislation, I doubt it will work, but at least on some stretches of the river Ganga, the one river, the main river, if that is cleaned, in the first, we can't clean a small stream, in the country, and we are talking about that we will be cleaning, So my only apprehension is that at least one river in the whole country should be cleaned. One river in the country. All rivers, all lakes, everything, the groundwater, everything is now polluted. So how are we going to do that? So at least the government of India, this $1 billion and $2 billion they are talking about, they are coming from the World Bank. This money should not be sunk into the river bed itself,
Sir.
So this is the situation, I'm very frank on this aspect, that we should see that the Ganga river should be cleaned, as that is the first focus,
Thank you very much, sir. Sir, if you can kindly focus on this issue that...
Yes, I'll try to answer the technical aspect of it, as Professor Dubey has raised, that whether the tributaries, which are, suppose a tributary runs only within a state, it does not run interstate, but it joins the main river Ganga, and if the tributary is not brought within the purview of this act, then the effluents, the pollutants which this tributary carries and throws in the main stream of Ganga, that will pollute the Ganga itself. So whether within the sweep of this legislation, a tributary which is confined within the particular state can be brought. It can be brought, and a similar provision should be made, because if we look at the the language used in entry 56, which is the central list, it says regulation and development of interstate rivers and river valleys to the extent to which such regulation and development under the control of the Union is declared by Parliament. Such regulation has to be first declared by Parliament to be expedient in public interest, as I have said. Secondly, you must understand that there are several judgments of the Supreme Court that these expressions which are used in the legislative entries, these entries, these are the legislative heads, and they have to be very broadly interpreted. The Supreme Court has interpreted these expressions, regulation and development. I will show you, it has interpreted these expressions, regulation and development, in entry 56 of list 1, and considered it wide enough to include the use, distribution and allocation of waters. So, if regulation and development is included to mean use, distribution and allocation of waters, then if a tributary distributes its waters and flows straightway into the Ganges, certainly it will come under 56. This is what I'm quoting from a judgment of the Supreme Court, which says that the expression regulation and development in entry 56 list 1 is wide enough to include use, distribution and allocation of the waters of interstate rivers as between riparian states. So that tributary may end up in a particular state, but since it is connected, so its distribution of water takes place in Ganga, which is in a different state. So it is coming under the purview of 56. But it has to be these tributaries. We have to define tributaries very broadly in your definition here. And there you would have said that this law you are making in public interest. That has to come in the preamble. So that will cover the constitutional question. And what Mr. Mehta says about the executive delay and all that, I share his views. And I tell you that if this law is enacted and is properly implemented,